Hi there, this is Jonathan Ginsberg. I'm a Social Security disability attorney, and what I'd like to talk to you today about is the delays in the Social Security disability process. And I'm sure if you've read anything about disability or seen some of my other videos, you know that the disability cases are backlogged for years. I mean, literally, it can take 2 to 3 years to get to a hearing, which is just absurd. It's shameful, and I think we all agree on that. Unfortunately, there's not a lot we can do about it. Social Security's backlogged, they're understaffed, and there's just not really a lot of relief coming for that. I think there's a lot of claims being filed, and it's a big problem. So we know it's a fact of life that you're going to be waiting a couple of years at least before your hearing. So the question is, what are you doing during that time? And you know the judge is going to ask you, what have you been doing? What do you do with yourself during the course of a day? And I think it's important that you go through with your lawyer and make sure you've got good answers for that, because there are certain answers and certain activities that are going to sound more like work or work-like activities, things that can hurt your case. And I'm not saying you shouldn't do things that give you pleasure, the things that are fulfilling to you, but just know what things are more damaging to your case and how you need to describe them, and maybe how you put limits on the amount of time you spend, because again, these are things that are going to hurt your case, and there's no need for them to do so. And again, if you are truly disabled and you're waiting for 2 or 3 years, it would be a shame to have your case denied because you testified maybe incorrectly or inaccurately about the things that you've been doing. So some of the things, I made a little list here, some of the things that I think have hurt clients in the past, and this is not just for me, but this is from some of my colleagues that we talk about these things. Things like if you testify that you go out and cut the grass on a regular basis. Well, that kind of sounds like landscaping work. It's physical. It requires a certain level of planning and concentration. If you do it regularly, that again sounds like you have some capacity to work. So again, occasionally going out and cutting the grass, and if it takes you 4 hours to do it, it should take a half hour. Not going to be a problem necessarily, but realize if you say, I cut the grass, the judge is going to assume you mean that you cut the grass every week and you spend 2 hours straight doing it and you're pushing a heavy lawnmower. It may be something very different, but again, that's something that you and your lawyer need to talk about. Vacuuming, and I'm not sure why vacuuming seems to be something that judges think is different than other housekeeping, but for some reason, if you say you're vacuuming, I guess the image that comes in mind is that you're pushing around a heavy vacuum all of your house, spending an hour and a half, 2 hours doing it. And for whatever reason, I've seen judges indicate in hearing decisions that they felt that the claimant was not entirely credible because he or she was vacuuming. Things dealing with your kids, like driving carpool. Again, once in a while, not going to be a problem, but if you go every day and you take your kids to school, you pick them up, and it's a 2 or 3 hour process, the judge may think, well, you know, the reason this person's applied for disability is because he or she wants the time off to raise his kids or her kids, as opposed to being disabled. So if you do carpool, you need to be able to explain how much time you spend, problems you may have, situations where you can't do it, whatever the case may be, but you need to be able to explain that. Same with like attending games, things, if you go into your kids' school and watching football games or baseball games in the hot sun. Judges want to know how you can do that, but you say you can't do a simple entry-level type of job. If you say that you piddle around on the computer, the judge is going to have this picture of you playing computer games for 4 hours a day. And again, that's inconsistent with not being able to work. If you can play computer games, then you could do data entry. So again, if you say you play on the computer, you check your email, make sure to specify how much time you spend, difficulty you have doing it. Maybe you're doing it while you're in bed or reclining, and you've got a laptop perched on your lap, whatever the situation may be. Just make sure that you explain it clearly. Going to school or taking classes, that sounds like work, and even though you're not getting paid for it, if you're going to school full-time or mostly full-time, the judge is going to view that like a part-time job and say, well, why can't you go to work if you're able to go to school? Cooking meals, and again, every once in a while, not a problem, but if every day you're cooking a 3 or 4 course meal for your family or for friends, that again sort of sounds like that you could do work in the cooking industry, a short order cook, a line prep, that sort of thing. So that needs to be explained. And of course, if you volunteer A lot of people want to do some volunteer work and help their community. I'm all for it. But if you volunteer on a regular basis for 4 hours a day, 4 or 5 days a week, the judge will deduce from that that you could probably do a simple entry-level job 8 hours or 7 hours a week, and that sort of sounds like work, which is inconsistent with being disabled. Now, there are some activities that you can do, I think, that can help your case specifically, and if you can do these things during the 2 or 3 years you're waiting, by all means go ahead and do them. And again, all this subject to advice from your lawyer. If you're able to lose weight, that shows you're trying to get better. And I think if you say to the judge, I've really made an effort to lose weight, maybe I'm exercising, especially low-impact exercising like working out in a pool or maybe on an elliptical, those things are helpful. I think it shows it enhances your credibility. I always tell my clients to talk to the judge about that if they've been able to lose 15 or 20 pounds, because losing weight is always going to be something that's going to help you feel better and be better physically as well as mentally. I think if you can stop smoking, that judges really appreciate that. I can't tell you how many times I've had cases that are kind of on the edge, somewhat marginal, and they went one way or the other because my client either was smoking or had quit smoking. If the client was smoking, the judge felt like, well, you're not helping yourself because smoking is obviously dangerous, bad for you. It makes surgery not work as well, all these type of things. Where if they were able to quit smoking it, the judge says, well, okay, you saw you had a health issue that you took care of, and I appreciate the fact that you did it because I know that it's hard. So again, if you can lose weight, you can stop smoking, do things to improve yourself, your physical health and your mental health, those are good things. And it goes along with making sure that you go to the doctor on a regular basis and that you're abiding by the medical treatment you've got. So those are some thoughts about activities that, again, you want to talk to your lawyer about them, but things I think that can possibly hurt your case and things that can most likely help your case. So I hope you found this helpful. If you did enjoy this video, please give it a thumbs up on YouTube or Facebook. Leave me a comment. Comments are always welcome, and it helps me as well. And of course, let me know if you have any other questions. Happy to try to answer those in future videos. My name, again, is Jonathan Ginsberg. I'm a Social Security Disability lawyer in Atlanta. And if I can be of assistance to you, give you a case evaluation, please feel free to let me know. Thanks a lot.